sentencing today. He's represented by his attorney, Ms. Russell. People are represented by Mr. Stay. Mr. Hanna's prior counsel filed a motion to withdraw the plea before sentencing. The court adjourned the hearing, which was previously set in, sentencing was set in February, to allow Ms. Russell to review the facts of the case and the volumes of discovery. The court did not hear anything whether she wanted to pursue the motion to withdraw the plea or wanted to continue on with the sentencing today. So what does the client wish to do today, Ms. Russell?
Your Honor, I've had extensive discussions with Mr. Hanna about how to proceed in this case in light of the plea, or excuse me, the motion to withdraw his plea. And he informed me late in the afternoon on Friday that he wishes to pursue his motion to withdraw his plea still. That is against legal advice, and he understands that, but he would like the court to consider his motion to withdraw his plea. We don't have anything to add to the pleadings as they were filed by Mr. Fabian. I've had an opportunity to review the plea transcript which Mr. Fabian had not had the opportunity to do. He didn't have a copy of that at the time he filed this motion, but I didn't see anything in the plea proceedings to warrant amending the motion to include a defect in the plea proceedings. I think that the only thing the court can consider at this time is in the interest of justice based on what's reviewed.
And why do you think it's in the interest of justice for Mr. Hanna to withdraw this plea?
Mr. Hanna believes that the people would not be able to prove that he had the intent to murder, which is a requirement for the assault with intent to commit murder, not just a reckless disregard for life. So he believes that he did not possess that specific intent, and that charge could not be.
Mr. Stay?
Your Honor, I did respond to that particular reason that has been forwarded by the defendant as a fair and just reason. And I would rely on my brief, but I want to make a couple of comments because some things happened after happened in court after that motion was filed last time. So he's filed a motion to withdraw the plea based on the interest of justice and that his fair and just reasons and meritorious defense. My first response to that is that if the rule were just that you could pick out one element and just say, hey, I could have defended that, anybody could get out of it. And we've abandoned, the courts have abandoned the great liberality standard that was in existence until in the 90s. That's gone, okay? The evidence in this case is strong, and the people believe that this reason is in fact a ruse, and concerns about sentencing are the real reasons why the defendant filed this motion. And I want to talk quickly about that. I know the court has read all these filings and heard everything, but to go over some of the timeline, we have a March 2nd, 2022 offense date here. The case was pending for a period of 8 months, and towards December started to get some more activity. A Cobb's hearing was requested on December 12th, 2022, and that Cobb's hearing was conducted on January 3rd, 2023, and the court during that Cobb's hearing made it explicitly clear what the potential sentence was should the defendant enter a plea. And under that Cobb's agreement, the defendant entered a plea on January 6th, 2023. My court record, or my file records indicate that we received the pre-sentence investigation on February 16th. And the recommendation in that is for a lengthy prison sentence. As the court knows, the court has a copy of it. That the motion to withdraw a plea was then filed on February 21st, which probably would have been a few days after the defendant would have seen that recommendation. I responded within 3 days, and then the sentence was already set on February 27th. And I think that's very important, the timing of when this motion was filed, okay? And obviously, Ms. Russell wasn't here for Mr. Fabian's representation, but it's clear from the record that he went over these things with him, and he even mentions that on page 6 of the on February 27th, which was the motion to withdraw. Mr. Fabian indicates that he spent a significant amount of time discussing the plea offer. And on page 5 of that, and this is what I wanted to add and why the timeline is important, the defendant forwards to the court there that there was some miscommunication, that he didn't understand what was going on. And that is just not supported by the record. It was a very, the plea followed the correct plea colloquy. I recall the plea, there were no hemming and hawing or anything like that. And that's also in conjunction with the court indicating what the agreement would look like at the Cobb's hearing as well. So what do we have here? We have what I like to call buyer's remorse. The defendant knowingly entered into this agreement, and then when he gets the pre-sentence and sees the recommendation, which is consistent with that plea agreement and the Cobb's agreement, he wants out of the deal. It's a concern with sentencing, and pursuant to People versus Haynes, which is 221 Mishap 551, concerns as to sentencing are generally regarded as frivolous in the context of a motion to withdraw a plea. That's what we have here, and the court should deny the motion and proceed to sentencing.
If you're prepared to address the issue, what facts would you bring forward to support finding the court that Mr. Hanna did have the intent to kill?
We have a defendant who had a list written down. He had things that were going to be used to tie up the victim. Okay, he laid in wait for quite a period of time. The court heard for a little while the people were even at the home in their apartment. Right, when he is caught, all right, that is really what we've got. The assault. That's really where the assault with intent to murder evidence is the strongest. We have him running after Keegan Ostrander with a knife, okay, and Jewel Daniels, and they're begging for their lives. He puts the female victim, Miss Daniels, on her knees and slits her throat, okay? She's lucky to be alive. If slitting someone's throat from ear to ear, for a lack of a better term, doesn't manifest an intent to kill, I don't know what does. And she goes down onto the ground, and then he continues to run after, with a knife, Keegan Ostrander. And what is the only thing that stops this assault? But thankfully, coming to is Miss Daniels, who is able to grab the knife that the defendant has in her hand, further injuring herself, and then stabbing him in the back, and then he runs out. They basically had to flip the assault on him to prevent themselves from being killed. It is one of the worst knife attacks that this prosecutor has ever seen in their career. It is some of the worst injuries that I have ever seen from a victim that did not result in the victim's death. So in my mind, this is extremely strong evidence of assault with intent to murder.
This knife that was used, is that something that was found in the home of the victims, or is that something that he brought with him?
If I could have a moment, Your Honor, to speak to the detective. I don't recall off the top of my head.
My memory was that it was something that he brought to his house, but I want to make sure that that's accurate.
Yes, that is accurate.
And Ms. Russell, did you want to address facts that you think would point to that there was an intent to murder, that there was not an intent to murder?
The facts as laid out by Mr. Stay are the facts that I have gleaned from my own review file. And while those may be presented to a jury, I know that my client may elect to exercise his right to testify at trial so that he can tell his side of the story. And that is one thing that is missing from the entire narrative that has been presented up to this point, is that my client did not speak to the police and did not have an opportunity to testify to what had happened from his perspective. I would also note that, the injuries on both individuals are quite different. Ms. Daniels' injuries were certainly, more worse than the injuries of Mr. Ostrander. So it is possible that as it relates to at least that victim, there is potential that based on the level of injury, that there may not have been the same intent to kill, if that could indeed be proven even as to Ms. Daniels.
The court is going to deny the motion to withdraw the plea. The court is guided by MCR 6.310B, which requires a plea, which provides that a plea may be withdrawn on defendant's motion or with his consent, only in the interest of justice. There's various cases that describe what the interests of justice are. None of those apply in this case. The defendant has not claimed his actual innocence. Basically, he wants to relitigate elements of the offense that the court found after reviewing the facts for the no contest plea did appear in the reports that were provided in the court. So, and adopting Mr. Stay's rendition of facts, certainly Mr. Hanna's intent can be inferred by the facts of this case. He had had in contact with these individuals for a number of years, got into their house without permission, stayed there for an extended period of time, brought a knife from home, brought binding agents from home, and had the people on the knees, and the brutality of the attack, the calculatedness of the attack, all show that he did have the intent to murder both victims in this case. And so the court is finding that it's not in the interest of justice to have him withdraw his plea. The court has had an opportunity to review the transcripts of the plea-taking process. And the court found no error in that. The court complied with NCR 6.302 explicitly, and I think this was a knowing, voluntary, and accurate plea. As to any claim that this was some sort of surprised sentence, that is cannot be argued with any sort of degree of certainty. The court was very explicit with Mr. Hanna as to what the potential sentence would be at the cops hearing. He was given a couple of days to go over that with his attorney. I believe that he understood that, and I don't think there's any confusion as to what his worst case scenario would be in this case. He may have been hoping for less, and we haven't even been sentenced. What we're looking at was the recommendation from the Department of Corrections. So I think Mr. Stay is correct that this is a case of buyer's remorse, and for those reasons, the court is denying the motion to withdraw the plea. That leads us to sentencing. Was the pre-sentence investigation report timely made available to the prosecution and the defense?
It was, Your Honor.
Yes, Your Honor.
And Your Honor, I do have the victims who would like to make a statement.
All right, let's do that first.
Good luck.
State your name for the record, please.
Jewel Daniels.
Go ahead, Ms. Daniels.
So, Your Honor, I come forward today to describe the emotional, physical, and financial damage that Deion or Hanna has cowardly placed upon not only Keegan and I, but both of our families. I did not expect Deion to react to anything that he hears in this statement today. That would take courage, humility, and kindness. Clearly, he lacks all of those traits. I make this statement to be heard by Deion's parole board, the court, the rest of the community who stood by us through this very difficult experience. But anytime you sentence Mr. Hanna will never be enough. We hope the court understands the physical injuries described in the preliminary hearing were truly horrific, requiring extensive medical care. However, this is how they are now, how I have to live. Overall, the doctor said I might get 1 millimeter of feeling back in my hands per year of every area damaged by Deion Hanna. My lip and top of my ear were almost completely severed off and had to be sewn back on. I can still feel my ear every time I sleep, and I can still feel my lip every time I talk. My 3 front teeth were fractured to the bone and had to be ripped out while I was awake, right after I left the hospital. I felt the bone in my teeth crack as they took it out piece by piece and then ended up taking a 4th tooth to make room so I could eventually get implants. I've had so many needles put into my mouth, I can't even count. I've had 3 procedures just to save what's left so I'd be able to smile again. I am a 23-year-old woman who had to live without teeth for a whole year. I am currently looking into surgeons to fix my lip now that over time the scar tissue has built up. I had multiple lacerations on my head, which I can still feel when I brush my hair. And then months later, in September, when I thought most of my physical injuries were finally starting to be less and less each day, I got diagnosed with post-concussion syndrome resulting in a brain injury from Deion hacking me in the face and in the head. I had constant migraines every day. I couldn't drive more than 20 minutes without feeling dizzy. I had trouble focusing, and I suffered from minor short-term memory loss. To everyone, this seems just like a terrifying, horrible day, but that day lives on repeat for months. And with all those physical injuries, there comes a price. Just for my teeth alone was almost $30,000 out of pocket that I had to pay just to be able to smile again. I had to pay for the smile that Deion Hanna took away from me, which Deion did not have to pay for. I was out of work for 3 months, so I had no income coming in. My financial costs also includes mental therapy, the multiple surgeries, the hospital stay, the 3 different types of physical therapy I had to do just to be able to get to where I am today. I had about 10 appointments a week for months, and on top of that, I had to and still have to pay for non-medical damages he did to me. I had to replace everything that was in my apartment because of Deion. Deion caused so much blood to be all over my property, my clothes, my furniture, my pictures, everything. Everything is gone. He took the place I call home for the last 3 years away from me. I went from living on my own to living with my parents in a matter of 24 hours. I had to use the money we were trying to save to buy a house and for our wedding, that's in September, on my injuries and to replace the things I lost. Not only am I left with physical injuries that are still healing and appointments I'm having to pay for, but now emotionally I'm not the same person I used to be. Growing up, I never believed the stories about monsters in your closet until I had to live it myself. He waited in my closet for God knows how long, just waiting for me to come home. I'm terrified to walk into anywhere with shut doors or cracked doors now. If I'm the first one home after work and no one's in the house, I will wait outside of my car or I'll drive in circles around the block because I'm terrified to be alone. Why do I have to live like this and he doesn't? I was alone with him for over an hour before he attacked. He heard me on the phone, he saw me through the cracks in my door and waited for me to go into my bedroom. If Keegan did not come home when he did, I promise you, Deion would have murdered me and I would not be here today. My family had to grieve as if they lost me, not knowing if I was alive when they first heard the news. I remember being in that hospital, remember every single needle that got placed in my skin that night, as 6 nurses had to hold me down. I had to be awake for all of it because of my blood loss. Your Honor, this poor excuse of a human before you is a monster. Allow me to explain Deion's actions the night of March of 2022 for the record. After attacking me when I was alone in my bedroom with a knife, Deion forced me into a small hallway and in the living room. When Keegan and I pleaded for our life, he forced me onto my knees. As Deion was staring at me, I begged for my life and I tried telling him that we were getting married and I would give him whatever he wanted if he let us go. I remember the look he gave me, and instead of taking that out by leaving the apartment, Deion made Keegan watch as he slit my throat with a knife in front of him and threw me to the floor like I was garbage, like I was nothing, and then proceeded to run at Keegan to finish the job. I can go on and on about the facts that Deion was wearing a mask and gloves and jackets and how planned this was and how he was prepared to kill me. I could also go on detailing the violence Deion committed, but I assure you it may give him some gross satisfaction. But all the details are in the police report. I frankly don't care what Deion tries telling himself or why he did it, because there is none. The only reason I'm alive in front of you today is because when he was running at Keegan, I got the strength to pick myself off the ground and fight back. After defending myself and Keegan, Deion ran away like a scared coward. I had to endure over 17 lacerations, and he endured 1 knife. one knife wound. The evidence showing Deion's guilt is overwhelming. Every day we have to live with all these burdens placed upon us. We did not have a choice, and Deion did. Deion made the choice to break into my home and assault both of us for no reason. His family and his attorney may say this is out of character for him, but it's out of character for anyone to break into and attack people in their own home. Every murderer has their first kill or their first try, and we were Deion. Deion made me terrified of my own town. I used to never feel unsafe or scared when being in Fairmont because it was my home. This small town where everyone knows everyone, before the crime, I felt safe, and now I don't even like to walk to my car after work in broad daylight. Your Honor, at the cops hearing, you stated that you weren't sure what was worse, surviving the attack or dying. Well, when you're dead, you do not have to wake up with nightmares. You don't have to pay for the damages done. You don't have to wake up every day wondering when or if he's going to come back after you or someone you love. You don't have to look at yourself and see all your scars and wonder why you. Being dead is far more easier than surviving. And Deion, I did nothing to you. Keegan did nothing to you. I was your friend at one point, and when no one did anything for your birthday, I went and bought you a cake. When you needed a ride, I gave you one, and when you wanted to chat, I listened. You sat there and had me beg for my life, and you did not care. And on top of it, you made Keegan watch as you proceeded to attack me. I don't know when you became so evil, so cruel. However, this is the last time you will see me and Keegan. 2 years ago, Deion, you should have been locked behind bars for what you did in Oceana County. But instead, you got let off. You got congratulated with a celebratory dinner by your family. But this time, while you go back in a cell and wait to be transferred to prison, our families will be having that same celebratory dinner because you are finally right where you belong. While you are stuck in prison, we are going to be living our life, finally moving on, and leaving you in the past. Although this trauma will never fully go away, I'll be happy to know that we put you there. I hope you regret breaking into our home. I hope you're embarrassed that me, a 23-year-old woman, overpowered you with a slit throat and severed hands. The scar on your back will always be a reminder of what you did and how you failed. And after the case in Oceana County, you could have changed. You could have had a life, a family, but instead you tried attacking me, and now you won't have the option. That is a decision you have to deal with for the rest of your life and something you will have to think about while you stay in your cell. So I hope you're happy with your decision because you made your bed and now you have to lay in it. Your Honor, respectfully, I hope you would sentence him as if this was your daughter because it could have been. And Deion, respectfully, go fuck yourself.
Mr. Bradley, is there anything that you'd like to say?
Ostrander.
Oh, I'm sorry.
I was like,
Sorry. Mr. Ostrander.
Yeah. Your Honor, it's been over 1 year since the horrible attack on Jewel and I in our home. That night we were terrorized, we had to fight for our lives, and we just barely succeeded. I'm supposed to stand in front of this room today and talk about what happened and my feelings. Although it has been a year and we have been both in therapy, I struggle with expressing my thoughts and feelings. I will do my best to walk through you that night and what it's done to my life. For the last 4 years, I worked third shift and Jules worked first. I would leave at 5 and she would normally be getting home by 5:15. 3 months before the attack, I switched to first shift to think that if I didn't, she probably wouldn't be alive. That night plays on repeat in my head to this day, and I doubt that I'll ever forget about it. Now that I have to live with the constant thoughts of that day. What if I did this? What if I stayed home from that work that day? What if I told her to go to her friend's house and we found out that it was locked, the bathroom door was locked? Just the feeling that I could have done more to protect Jules. The image of seeing Jules' throat get cut in front of me and seeing her covered in blood will forever scar me. Seeing her cry because of what happened filled me with sadness, anger, and depression. So much going through my head that I just didn't know what to do. I could sit here for 20 minutes describing that night in detail to try to get you to understand what we were put through, but honestly, I can barely stomach it, and I doubt most of you will either. The images from that night will always be scarred in my head. The anxiety and fear I feel every day. I fear being alone. I fear not being able to protect Jules and myself. I fear empty rooms and closed doors. The list goes on and on. I rarely sleep. My nights are plagued with nightmares. Deion has changed our lives forever. Anytime that he is free, I will fear that he will come back after us or someone that we care about. Your Honor, I would like you to think for a moment if you were in my shoes that night, coming home after work, expecting some dinner and to relax with the love of your life. That night, just to come home to terror, fear, and the worst nightmare you can think of. To fend for you and your wife's lives, to see her get her throat cut right in front of you, even though you begged and pleaded with all that you have. just to see him not care and to throw her like trash on the ground in front of you, feeling hopeless, feeling weak, and feeling useless. Just take a moment, think what you would like him sentenced if this happened to you. And I'm gonna say the same thing. Fuck you, Deion.
Ms. Russell, have you had the opportunity to read the report and discuss it with Mr. Hanna?
Yes, Your Honor.
Do you have any additions, corrections, or challenges?
As it relates to the scoring, it won't change the guidelines, but for, one of the assaults with intent to commit murder, OB 17 is scored.
Ms. Russell, can you keep your voice up, please?
I'm sorry. Did you need me to repeat it?
For one of the assaults with intent to commit murder,
Offense variable 17 is scored at 10. That's inappropriate because that only applies if a vehicle is involved. I think that should be scored at 0. The same scoring mistake is on the home invasion first degree as well, and would ask the court to note that. Otherwise, I have no other additions or corrections.
Mr. Stagg?
People agree with that.
So making that adjustment, was to one count with the assault with intent to murder, that would put the OV points at 200. And for the home invasion first degree at 160. It doesn't appear that that would affect the scoring of the guidelines. Any other additions, corrections, or challenges, Ms. Russell?
None, Your Honor.
Is there anything that you'd like to say on Mr. Hanna's behalf before the court imposes sentence?
Yes, Your Honor, thank you. This is a significant case, clearly emotional. I know it takes a lot of courage for people to come up here and share not only what happened to them, but the vulnerabilities that have been exposed. And it's pretty hard to follow that, to be honest with you. What I would ask the court to consider in sentencing and determining where in the guideline range to sentence my client, just a few things. We are all made up of our past and the steps that get us from point A to point B. And I know that Mr. Hanna was in the neglect abuse system. I know that there clearly are likely mental health problems, and just based on some of the prior information, perhaps even a substance abuse problem. All of these things could lead to one to make a decision that is not in line with what the law allows, and I think that that's what brings us here today. I don't, based on my client's history, and I say this especially in light of what Ms. Daniel said in her statement, I don't know Mr. Hanna personally, other than what I've gotten to know of him over the last few months since I've taken this case over. This does not appear to be something that is historically who he is. He doesn't have a juvenile record, and he has one other prior that he was on probation for, under HIDA actually. That tells me that who he is a bigger picture than this isolated incident. He's a young man who is looking at a long time in prison without question. Even if you were to sentence him to the bottom of the guidelines, that's well over a decade of his life that will be spent in prison, likely more than that. I doubt he would be paroled on the first request for that. And he could spend up to 60 years based on the plea agreement as it's been laid out. I would ask the court to just consider his youth, his background, and the lack of juvenile history when looking at the amount of time that he would spend initially in prison, and to consider a sentence that is near the times.
Thank you, Ms. Wilson. And Mr. Hanna, have you had the opportunity to read the report and discuss it with Ms. Russell?
I have.
Do you have any additions, corrections, or challenges?
I do not.
Is there anything that you'd like to say on your own behalf? Mr. Stay, any additions, corrections, or challenges?
I have one, offense variable challenge, Your Honor. On count 1, OB3, for the attack on Jewel, I would indicate instead of 10 points, it should be 25 points for life-threatening injury or permanently incapacitating injury.
Any argument, Ms. Russell?
No, Your Honor, I would not necessarily disagree with that.
All right, the court agrees. Offense variable 3 would be scored 25 points for life-threatening or permanent incapacitating injuries occurred to a victim, certainly having their throat slashed. And the amount of blood that was described being lost, it could be life-threatening.
I do have a restitution request that's going to be in excess of $97,000. What I'm asking, some of these costs are obviously continuing, especially for Mr. Daniels. What I'm asking for the court is the court to set a restitution hearing in 30 days. I will get a better compilation of that restitution, of those restitution figures, and speak with Ms. Russell to see if we can agree on certain amounts, and if we need to have a restitution hearing. I know the court doesn't have time for that today, nor do I think it's appropriate today.
Couple of questions for you on the restitution. Is this a situation where there wasn't any medical or dental insurance?
So, there is some medical insurance, but not dental.
Okay,
To generalize, the dental was not covered, the medical was mostly done. Then we also have the destruction of the apartment by the landlord. We have the destruction of some of the belongings. The court has seen some of the pictures. I mean, many of their items were destroyed, whether by blood or otherwise. We have quite a bit of lost wages, especially for both of them, because of this crime. And I'm satisfied that I can get to Ms. Russell a more itemized detail of those numbers.
so, all right, so certainly my concern is that the victims in this case can have as little as out-of-pocket expenses as possible. And obviously I can order hundreds of thousands of dollars in restitution, which will most likely never be paid by Mr. Hanna given the situation. I know that the prosecution is well aware of the services and compensation available through the Crime Victims' Rights Bureau. Hopefully that those are exhausted. That's why every criminal defendant is charged a Crime Victims' Rights Fund fee, just for these circumstances. Hopefully that they can avail themselves of some of those services to help defray the costs or cover future expenses.
Right, and I have discussed that with you. Thank you.
Anything else that you want to say, Mr. Stitt?
I do, Your Honor. The court has to look at the defendant and has to look at the crime, and I want to make a couple comments about the defendant's situation at the time of the crime. We have a 24-year-old, now 25-year-old defendant. The court is not looking at a teenager or somebody young, somebody who's been out of high school for several years. He was on Home's youthful trainee status for an unconsented sexual encounter in August of 2020. So we have an individual who, even while under felony state probation supervision, is unable to conform his conduct to the tenets of the law. Now let's look at the crime. I can't explain what happened and the effects it had on Jewel and Keegan better than they can. But I know this court sees a lot of cases. We see a lot of assaults. This is one of the worst, most violent, sadistic, unprovoked attacks that I've ever seen. These two are lucky, they said it themselves, to escape with their lives. I think that fear that they have is a reasonable one. First, the home invasion. We don't have an attack that happened out on the street or while they're at a party or at a business. They were in their very home, their apartment. There is a sanctity to the home where people should be able to feel safe, especially in this county. And the defendant, while masked with binding agents and obviously ill intent, was laying in wait for them, okay? And so the home invasion is an important component of these charges as well. Now the assault, the 2 assault with intent to murders, again, I'm not gonna go over with the court all of the details of this assault, but we're talking about Jewel getting her throat slashed and the defendant running around uncontrolled in this apartment attempting to hack at these 2. The fact that she was able to fight him off is just unbelievable. And you know, I'm sort of in awe of the strength and courage of both of these 2 to participate in this prosecution after what Keegan referred to, a nightmare. It's a nightmare. This court knows that I don't make a lot of plea offers that exceed the statutory guidelines, but I felt it was imperative in this case. I am asking that the court sentence to the top of the Cobb's agreement that the court entered to back in January and send the defendant to the Department of Corrections where he cannot hurt anybody for a long period of time.
Thank you, Mr. Stain. So we're dealing with 3 counts here. Count 1, we identified as assault with intent to commit the crime of murder. Dealing with Jewel, the court recognizes that the advisory guidelines will suggest a sentence between 14.25 years and 23.75 years. The court is going to exercise my discretion to sentence consistent with the plea agreement, consistent with the Cobb's agreement, and consistent with the advisory guidelines. It will be the sentence of the court that this defendant served 23.75 years to a maximum of 60 years with the Michigan Department of Corrections. He would be given credit, I calculated at 437 days. For this count, there's a $68 state cost assessment, $130 crime victims' rights fund fee, and a $60 DNA fee. Count 2, assault with intent to murder involving Keegan, will be the sentence of the court that this defendant served 23.75 years to a maximum of 60 years with the Michigan Department of Corrections. This is credit for 437 days. I'm exercising my discretion since it's consistent with the plea agreement, consistent with the advisory guidelines, and consistent with the Cobb's agreement. Count 3, home invasion, first degree. The court recognizes that the advisory guidelines in that case would suggest a sentence between 7 years and 11 2/3 years. The courts can exercise their discretion since it's consistent with the advisory guidelines, consistent with the plea agreement in this case. Be the sentence of the court that this defendant served 11 years on the minimum to a maximum of 20 years with the Michigan Department of Corrections. There is a $68 state cost assessment for count 3 and count 2, if I didn't mention it already. And of course, reserving restitution pending a motion by the prosecution. Counts 1, 2, and 3 will run concurrently. And Mr. Hanna, it gives me no pleasure to sentence you to this amount of time. I've known of you for most of your life, as I've indicated on the record before, that you're friends with your daughter. You've worked for me at the house on occasion. I've seen you around, watched you grow up. You weren't raised this way. Your family's not this way. The school system doesn't produce people like you. The community typically doesn't produce people that do these sort of things. Only you know what happened in your life to bring you to this situation, but it's one that 23 years of doing good and living right cannot undo. You've demonstrated by your actions that you're not safe to be in the community. You attack people, you almost kill them. At any given time, you could have left. You laid in wait for who knows how long, but you could have left. You could have come to your senses and said, who am I? I'm not this guy. I'm not going to do this. When they were pleading for their life, you could have left. You didn't have to try and kill them. Lots of chances to be the type of person that your family thinks you are and some people in the community think you are, but at that time, you chose to attack them viciously, violently, almost killing them. And for that, the court cannot overlook that. By your actions, you earned the maximum sentence that I can give you according to the plea agreement, and that's what I've done. You do have the right to make application, leave to appeal the conviction and sentence. If you cannot afford an attorney, the court appoint an attorney to represent you as public expense. Request for a lawyer must be filed in court within 42 days. That's all for today.